Hi, this is Peggy Clary of Clary Law Offices, one of our estate planning attorneys at the firm, and tonight doing our video chat on a topic of estate planning interests. And what prompts our discussion tonight is really the face painting, which I know can be hard to see, but is a face painted octopus that at a fundraising event I went to. They had volunteers put designs on as part of efforts to help raise money for Griswold Home Care, and this organization is really helpful in providing care services for seniors or other individuals that need more physical aid at home. And so they had a wonderful event in our area to help raise funds for those efforts. But the face painting gave me a great suggestion tonight for the topic, which is really about when something in your life happens that you weren't expecting or maybe a little surprising. And for many people, that can be a later in life marriage, maybe a second marriage if their spouse has died, or sadly if they've had a divorce, maybe they elect to remarry. And then suddenly their whole world becomes much more joyous, hopefully, for that reason. But also it's important to remember the effect of that marriage on your estate plan. And so for Florida law, if you remarry or marry and you have a prior will, and that prior will does not reference the spouse, then if you pass and there's no update to that will, no special waiver of spousal rights done, Florida law will give automatically a term called pretermitted spouse. And it means we've had someone die here with a will. However, at the time they died, they were married. They didn't mention the spouse or this marriage, so Florida law will give that surviving spouse statutory rights that would fall to them as though you had died intestacy. So as an example of that, so you don't feel like you're sitting through Law School 101, let's say I remarry and I have 3 children from a prior relationship. And then I have a will that before I got remarried that I leave everything to these 3 children. But once I remarry, if I don't go in and update that will to reflect that marriage, then if I die suddenly, Florida law, applying intestacy laws because I'm married, will give 50% of my estate to my spouse and then divide 50% among the children. Now, that seems like a huge change. So if you don't want to have this pretermitted spouse and intestacy language attach and treatment attach, it's very important that if you're considering a remarriage or if you have remarried and have not updated your will, that you visit with an estate planning attorney so you can do the necessary steps under Florida law to make sure your wishes that you have generated under this will are followed. Those steps are many different options. We're going to cover them in another video topic, but in quick summary, your new spouse can say, I don't want anything, just leave it like it is. You can do other types of trust planning for that, but at least acknowledging there is a spouse through a codicil to your will is a very important step. So I hope this helps if you're thinking about remarriage or if you're marrying for the first time and have a prior will. But either way, we hope you live your life at Clary Law with life marked by civility, dignity, and respect. And if you do any face painting, I recommend the octopus. They're lots of fun and hopefully will be easy to get off. And thanks again for your time and have a good evening.